one knows my password. Yes. Still? Yes. Oh, why did I get
told that you guys should not have.
Sorry. What joke did I have? When I asked this, I was working. Send it. Well, I didn't remember. I didn't know.
He's gonna send us like 8 files now. He's gonna be like the emergency line.
I know. Did you see the GD file?
Everybody ready? I'll flash?
Yeah.
No? Great. Go.
It's not fair. He breathes. So you laugh.
Everyone good? Everyone got the email? Framework, I value justice. Structural balance and oppression is based in moral exclusion, which is following thought, because exclusion is not based on observant or arbitrary perceived differences. Opt-out 1. Structural violence involves moral justifications. Morals operations are a sense of justified identifying what we would impliedly value. Excluding people we hate and who dissemble entities. Exploitation of live seems normal and accessible. Social issues essentially moral debates about moral inclusion. Moral exclusion seems unjust. Our tendency to exclude people swaps by perceptual tendencies. Our tendency to classify social categories can be based on the rationalized structural inequality and social justice. Our tendency to make simple dichotomy in terms of features from perceptive justice have all components. And particularism is good. Root cause claims to focus on overarching structures ignore application of material injustice. Papa 16. Practice is supposed to be distinguished from theories and starting points in being justice at large. This is philosophical critique can be accomplished under critique of modernity. The practice does not deny the importance of power structures. We must study history but seek present evidence of the weight of the past. Practice is supposed to take treaty the particular situation not a global social pathology. Concepts of white supremacy and colonialism are tools to ameliorate particular injustices. The force that causes sustained domination vary. There is no single causal explanation. Principle is falsifiable and open to revision. Thus, the standard is reducing structural violence. Harms. Blue on black violence is structurally and legally justified. Police routinely violate the Fourth Amendment to use excessive force against black bodies. Carbono 16. Michael Brown's death was not a rogue officer acting outside normal police behavior. Social force converged to make African Americans vulnerable to police surveillance, broken windows policing, mass criminalization, racial segregation, criminality stereotype, criminality, predatory policing. Governmental officials and police leadership encourage officers to engage in predatory policing and crime law. Permits officers to follow and question people and to arrest for minor offenses. Stereotypes of African men as violent, dangerous, influence interaction. Police culture and training contribute to police violence. Since your lack of regard for police violence diminished likelihood that officers would be held accountable and increased likelihood that constitutional violations will occur. Thus, the law is currently a means by which police brutality becomes justified. Qualified immunity lets officers escape accountability. 2 warrants. 1. The clearly established clause in the merit sequencing precedent set by Pearson v. Callan means that courts can avoid the question of whether the officer's conduct violated the Constitution if the right isn't already clearly established. Creates a vicious cycle where the greater the uncertainty about the law, the easier it is to argue that the right was not clearly established. Leaves black bodies in a state of legal flux. Carbono 16. Courts often avoid deciding whether the officer's conduct violated the Constitution. The Supreme Court has made it clear that lower courts are free to proceed, making it easy for courts to make the defense of qualified immunity without having to decide whether the officer violated the Constitution right. This compounds the extent to which the law is unsettled. Greater uncertainty about the law, greater doctrine space for an officer to argue that rights were not clearly established. 2. The clearly established standard as presently interpreted virtually guarantees qualified immunity, so officers are almost never indicted. Carbono 16. The standards riddled with contradiction and complexities. Courts have permit several principles and unseen cases distinct from the case at hand. Clearly established law will be more likely to deny qualified immunity. Qualified immunity rests in significant doctrinal hurdle to holding police officers accountable for violence. And qualified immunity doesn't just mean that victims go without compensation. The clearly established right clause means that courts can continue to avoid clarifying the scope of the law, which prevents law from ever becoming clearly established. 10-15. Constitutional doctrines are defined through court decisions, but immunity reduces guidance about the meaning of the Constitution, lower courts have a green light to avoid harder constitutional law questions and decide the defendants entitled to immunity whether or not they violate the Constitution. In cases involving cutting-edge issues of the constitutional law, qualified immunity may prevent the law from ever becoming clearly established. And qualified immunity is focused on technicalities disguised as institutional racism and makes civil rights litigation about individual cases instead of structural problems and encourages acceptance of the status quo. We have to break down the illusion that our CGS allows for redress. House Law 99. Civil rights laws being designed in the dark community makes civil rights remedial system about individual cases. Without a clear rule, there's minimal pressure for change. Hiding the goals of communities why there's been little effective rallying for change. The remedial scheme that allows for tinkering at the margins but recasting in terms is unlikely. The Section 1983 statute seems to provide a powerful remedy against governmental abuse. Immunity severely limits that remedy, but on a case-by-case basis. Added collusion, spectacular success of a few high-profile cases. Immunity makes it difficult to see policy choices made in courts by civil rights actions. Cloaking avoids the possibility of an open debate. Thus, the plan. The United States federal government ought to limit qualified immunity for police officers by changing the clearly established right clause to clearly unconstitutional and implementing a three-part inquiry for cases in which the defendant's actions were not clearly unconstitutional. Cat Lit. 5. Court should first determine whether the official's actions were obviously unconstitutional. If so, qualified immunity should not be available. If not, the court should consider the following factors: has a particular constitutional right ever been announced in binding precedent? If not, has the consensus of cases announced that a particular constitutional right was ever pronounced as a broad principle, or was the pronouncement particularized? How recently was constitutional right pronounced? Solvency. Asking whether the defendant's actions were clearly unconstitutional as opposed to violating clearly established rights avoids legal technicalities that expose egregious behavior and shifts the focus to common social duty. Jeffries 10. Asking whether conduct is clearly unconstitutional is less cited precedent and less technical. In accordance with the nature of social duty, conduct can be clearly unconstitutional by contravening precedent or for clearly contravening constitutional principles. The nature of the constitutional violation would matter whether or not it had previously originated on closely similar facts. Egregiousness does not establish constitutionality, but neither should it be irrelevant. And the four-part inquiry establishes a uniform standard for settling constitutional merits, resolves the legal quagmire that unfairly protects the police. Cat Lit. 5. The proposed standard would provide uniformity, decrease uncertainty. Certain conduct is so egregious that no reasonable official would believe that such conduct is constitutional. Prior case law is not required to put the official on fair notice. When one kills, rapes, or tortures another human, no disability legality is conferred based on the brutal nature of the crime. Prosecution not expected to show the defendant was aware of the particular statute under which is charged. The use of binding precedent to determine qualified immunity makes sense. The Supreme Court consistently looks to its own opinion to determine clearly established. This approach comports with the doctrine of precedent. And civil lawsuits are good because they spur systemic reform through investigations and public outcry. Also, even if there's indemnity, that doesn't answer our office because victims still get reparations and recompense. 1096. Civil laws and interest as an instrument of systemic reform. Civil remedies offer distinctive advantages over criminal sanctions. Civil law can punish by imposition of punitive damages. Civil law provides compensation to victims who have been harmed by police misconduct. Damage towards consumer reform. Civil lawsuits permit the discovery of information out of police behavior and serve public reaction. The civil law offers equitable reasons that can force the government not only to pay for harm, but to reform. And we don't claim legal reform solves everything, just that it's a good idea. Even if institutions are racist, oppressed groups have to carve out anti-racist pockets in the Constitution and write themselves into the law as a pragmatic political strategy to break down the incoherence of dominant ideology. Crenshaw 88. Efforts to address racial domination must consider the ideology of right-based consciousness by uncovering oppositional dynamic and chipping away at it. Central to this task is revealing the constituency of race. African-American people must develop pragmatic political strategies. Black people cannot afford neither to resign themselves to nor to attack frontally legitimacy of the dominant ideology. The dominant ideology in modern capitalist society is highly institutionalized. Direct assault can result only in disappointment. The challenge is to create counter-hegemony by maneuvering within and expanding the dominant ideology to embrace change. We should develop visionary undercurrents. Institutional structure may be realized by piecemeal rather than all at once. And only struggles within the legal system solve. Pessimism is a solipsistic retreat that moots smaller points of attack on white supremacy. Lloyd 16. After pessimism reveals and solipsistic retreat in itself, white supremacy cuts off possibilities for black sociality and elasticity. It cuts off intergenerational transmission. What is left is the individual black mole and facing the indestructible behemoth of white supremacy. Must the black laws, national tradition, class when faced with the race legal system? I see no reason why. The cipher.
Ready?
Hard why.
First piece of Carbato evidence says that we don't establish what constitutional rights are applicable in court cases. Why does this matter?
The first piece of Carbato evidence is talking about white police brutality as a systemic issue.
Sorry, the second piece of Carbato evidence. I scrolled down a little bit further than I meant.
Okay, yeah. The second piece of Carbato evidence indicates that currently, because we look at things like the clearly established cause versus things like actually defining whether these rights are allowed.
I know what the piece of evidence says. My question is, why is establishing constitutional rights effective?
Establishing constitutional rights is effective because it causes things like we can actually decide whether or not officers get qualified immunity, and we can clarify the scope of the law.
Wait, this seems circular. You're saying that limiting qualified immunity is good because then we can decide whether people get qualified immunity. What's the external
No, it's not
impact
limiting
from
qualified
deciding
immunity is good.
constitutional
It's that my
rights?
mechanism for limiting it is good.
Yeah, no, I have a question about one of the
internal.
internal links that you isolate for your mechanism. My question is, why is establishing constitutional rights important, and where are there examples in your evidence that discusses when courts successfully, because of new constitutional clarifications, expanded rights to minority groups?
I mean, I would argue that things like constitutional protections do afford a greater scope of right. The Catlett evidence indicates, that's the solvency advocate, indicates that setting up these forms of limits and setting up these forms of questioning would create a greater process of accountability, because thus there are more steps the police officer has to go through to see if they qualify.
All right, what's the four-part inquiry thing? What is that?
Okay, the four-part inquiry thing begins with questions Basically, the first question is, we changed the clearly established right clause to the clearly unconstitutional, i.e. we ask if the officer's conduct was clearly unconstitutional and violated the Constitution. If it was, then they don't get qualified immunity, but if it was not, then the court looks at things like if the constitutional right has been announced and things like precedent. If it was not announced in precedent,
the court clearly, like, when they talk about a clearly established right, are referring to a constitutional right because SCOTUS evaluates the Constitution.
The
So
clearly
what is the
established right
difference
part
between a
refers to what exists in the status quo. Clearly unconstitutional, instead of saying whether or not the defendant had, or no, whether or not the person that was harmed by police brutality experienced something that is a clear violation of their rights, we look and see whether the officer did something that was a clear right violation within the Constitution, i.e.
Alright.
things like killing people, raping people, taking their property.
All right.
That's
You
clearly
say that
unconstitutional.
like lawsuits motivate people to speak out. When has this happened? Like, when has anyone ever specifically rallied because of a lawsuit specifically?
I would argue that forms of like civil rights movements have occurred in the past that probably resulted in
How are
some
those
form of change.
oriented
My
around
argument is that
lawsuits?
civil rights wasn't just oriented around lawsuits; it was also oriented around things like the system. But my argument is that lawsuits can do things to like either A, make people like upset about these issues and cause public outcry if they don't go through, or B, the lawsuits will go through and people will get things like reparations, which fundamentally decreases the harms of like bullet-free
What do
trauma.
reparations do? Why would like having a little bit more money stop police from killing people on the streets?
My argument is not that it stops people from like police from killing people, because that's just clearly not true. My argument is that it makes victims like have some form of appeasement, i.e. they are able to live some form of a better life, or at least attempt to like create
All right.
social dignity for themselves.
Starting from. $240. Full rough case. Can I use your stand? Actually, I might read them in a different order. Is that okay? Like, I can just tell you. I can change it now. Okay. Is everyone good? It'll actually go 4, 3, 2, 1. Is that good? In the doc.
Wait, one see Trump could win and then
Yes.
back
Exactly.
up?
Yeah. Up. So then it'll be the third one in the document. And then, yeah. Are we good?
Trump could win if there's one more disruption. Clinton's not as volatile as you think. Unstrategic solver. 11 would have also read it. The question about is how robust Clinton's lead would be into a modest error and pulling a further tightening of the racism and secure match for Clinton. Clinton would probably lose the electoral college and very close national popular. It's 100% to the right for Trump to be campaigning and risking in Wisconsin. Clinton spending time in Arizona is much more sustained. Liberal SCOTUS rulings become crucial Trump rallying points in its way. Uneasy Republicans app action, immigration proof Colville. 623 rulings on immigration and affirmative action help provide more justification for uneasy Republicans who that the course featured in a rare rally point. Trump said the split decision will be clear what is at stake in November. The Supreme Court is increasingly common reasons cited by the Republicans to get behind the presumptive nominee. The most important thing for the Republican Party is the Supreme Court. Police brutality reforms like the plan will trigger right-wing backlash and get Trump supporters at the polls. Only 7 more than half had very serious concerns about violence against police voters. So violence against police more serious concerns about violence against the public. 56% say they have very serious concerns about violence against police. 57% of white voters, only 45% view police violence against the public against as very serious fear. Just 39% of white voters link out ways last-minute distractions will flip the election. Empirically proven with Comey and the FBI. They're the only thing that distracts from Trump's record. And Trump sucks. He's racist and attacked to the KKK and turns policing, Islamophobia, poverty, overseas oppression, and security dangers. Ruben 821 Trump has championed law in order to reject the suggested legitimate complaints about policing. He's a light route to racial animus intention. We'd like a president who has any conception that there would be a problem. This is someone who declines to speak in an African American gathering. Someone who brought in the former head of the website contributed to white supremacy. The man heavily investing in birth rates. And there's a reason Trump's getting 1% of the African American vote. Trump demonizes all Muslims. Trump's solution will be how life harder than the poor. The parents will cut the average household 4% of their after-tax income. Imports will become more expensive. That would cut the impact of the shop for voters. Stand to lose to a president who funds every dictator to demonstrate that fact. Ignorance about nuclear arsenal undermines and NATO is going to order the military to commit war crimes or clap down on free press. Trump plans to add billions to the outweighs the case. 8-point evidence indicates that Trump specifically does not like police reforms, which means that whole definitely makes things more specifically in that context. B-point, Trump would probably roll back the plan because he dislikes any of these kinds of reforms. C-point, I access multiple external impacts like Islamophobia and global security dangers. Now, next off is the counterplan. The United States ought to abolish qualified immunity for police officers. Competitive one, mutually exclusivity. You can't limit something and eliminate this. They'll say this is plan flawed, but the plan isn't a question of like limiting qualified immunity by 20%. It is an actual action, which means that it is mutually exclusive with it. A separate action deals with qualified immunity a separate way. Second, redundancy. No policymaker would simultaneously pass 2 bills, which makes the other redundant. That's key to real world theory. Is net enough? And it solves the case. Human 16 acquittal of Baltimore police officer the death of Freddie Gray reveals the inadequacy of criminal law remedies. Suing the police under restraint of federal civil rights law would be a better response to police misconduct. Suing for money and federal civil rights is the only realistic way to establish misconduct and serve the indication for victims of the family. The defense of qualified immunity should be abolished. And officer violates the Constitution. The should win. Next off is next off. Interpretation plan must have a solvency advocate that explicitly advocates for every plaintiff of plan type violation. Your plan says changing the clearly established right clause, but your author doesn't defend changing it. Just a particular task for interpreting it. Here's your author, Catlett 05, in trying to decipher the constitutional rights clearly established. Courts should first determine whether the official's actions were obviously unconstitutional. Predictability. Few authors actually advocate changing the clearly established right clause since it's entrenched in legal precedent. Intensive law review articles defend it. You call predictability by defending a plan that's not part of the lit, abiding by what your solvency advocate actually said. But ensure the NA has some basis for predicting a plan that's key to Brown. There are authors who answer changing the clearly established right standards since it's not actually defended lit. Fairness is verdict. Debates and connectivity requires an objective evaluation for education is verdict's intrinsic purpose. Debate dropped the debater. The visa has already occurred. And my time allocation has shifted. Also, the stall indices your whole advocacy justifies separate which use my strategy competing interests to raise to the top to figure out the best possible enrollment and avoid judge interventions to deserve a clear bright line. No RBIs counter-check. They get an RBI for read 3 or more sold 8-point bidding. They'll just make the 3 debate private justifies infinite abuse and results in that shall be one or all. So left entirely through which house has skills education. Next off, interpretation. The often specify who pays for the damage resulting from successful lawsuits. The world of limited qualified immunity. Burning 15 clarifies 3 methods. Police officers can be held personally liable for any rights violations. They need to carry personal back charges. In turn, police departments can be held liable for any rights violations. Police departments can be required to ensure officers up to a certain about violation. They don't standard. One single ground 100% keep negative invites on the efficacy of lawsuits is discerned since whether individual police or the departments pay for them hugely affects how they're perceived. If I read articles about deterrents resulting from police having to pay themselves, I'll shift and vice versa. 2, deficits. It's a key policy discussion. My interprets that can read CPs that test the offense's funding source. It's a huge question to expand police officers and educationally irresponsible for them to leave this out of the case. First, rates write-off turns case file in 11. Immunity is not very real one concept, but one variable among others. In the absence of immunity doctrines, codified forms like prove more hesitant to extend constitutional rights. Even some currently well-established rights would likely swing according to the equal agencies. Substantive rights, causes of action, rules of pleading, improvement. Immunity doctrines are all flexible components of the practice of rights that should be viewed as a whole. The equally run through this concept immunity is a mechanism for achieving the best possible overall bundle of rights. Police culture is intractable. Blank 15. The precinct tried to coordinate effort to lie by crime sets and internal cultural code that Trump's constitutional policing replaces with how things are really done, forcing trust and loyalty among officers' rights. The penalty for every reaching of the officer system harassment awards is as simple as offering as officers covering for one another. And officers and agencies won't pay, and even if they do, it won't solve Schwartz. 16 police officers and 81 agencies are virtually always indemnified. offers personally satisfied just 0.02% sues alleging constitutional violations when a plaintiff sues any amount is almost certainly not to confront the fact that officer settlements and judgments are not usually paid from a judge or jurisdiction. Judge will have to require law enforcement agency to pay near the sufficient or necessary to put financial burden agencies reviews and allocation of funding litigation costs during the budgeting process outweighs absolvency. You have a couple of interlies. First, you say that it clearly establishes constitutional rights, but there are no examples of more clearly established constitutional rights actually spilling over to create any kind of material change in the way that courts make decisions. The courts make decisions. Obviously, they have incentivized that they are incentivized to maintain the current system, which means that you should hold them to a high burden for explaining how this would actually happen. Also, you also say that that lawsuits would lead to the public consciousness revolting against the system. That a point this has diminishing marginal returns. There are some lawsuits in the score, which means that the very least that's mitigation. The score is not better. B point. There's no reason why B point. You still don't establish a full internal link because there's no reason why the public revolting would actually be able to do anything to combat police brutality. Proved by the fact that things like the Black Lives Matter movement are accelerating the status quo, but police brutality is only increasing. And then Plainwood overburdening federal courts. That would mean no lawsuits. Patent first 92 resources are scarce. Increasing number of Section 1983 actions are being filed under overburdened federal courts. Reducing the load as essential courts have questioned whether the abundance of cases in federal courts and efficient use of judicial resources. Suits concerning constitutional violation need not proceed to trial but can be terminated. And the defense of immunity procedure will ensure that federal officials are not harassed by frivolous lawsuits. I'll be reading one more card. I'll flash it after. Actually, that's fine.
Alright. Is everyone ready?
Yep.
Okay. What's the status of the counterclaim?
Conditional.
Okay, cool. Then let's talk about the solvency applicant interpretation. Your violation says that the claim doesn't say that we should change the constitutionally established right clause, but my solvency advocate says that we should first determine whether the official's actions were obviously unconstitutional.
Your solvency advocate says that your solvency advocate says that we should use that standard for determining whether a constitutional right is clearly established. It doesn't say that we should change the clearly established standard. It just says that we should have a different mechanism for changing.
It just indicates that instead of using that standard,
I have a line from your solvency advocate that says, quote, in trying to decide whether a constitutional right is clearly established.
Let's talk about the first interpretation. You say that the affirms to specify who pays for damages. What specific decides and what stable ground did you lose as a result of me potentially not
right, so
specifying
there are a lot of pieces of offense in the shell. The first argument is that,
No, what specific decide grounds? I want you to name specific arguments that you could not read.
Yeah, so if you don't specify what kind of funding happens, then that means I don't get access to decides about funding sources. For example, things like insurance liability increasing, or the nature of insurance companies with regards to how they hold police departments accountable, which is also a case argument that you prevent me from being able to make.
But didn't you make that argument case on case?
I didn't talk about insurance companies because you could do links. So.
Okay, that's fine. Let's talk about the counterclaim. You say that we should abolish qualified immunity and that it solves case. Why does abolishing it solve? What about officers that did not actually violate people's constitutional rights that deserve some form of protection?
I don't think they deserve any more protection than anyone else does in the context of a lawsuit. You can make that offensive argument, but it's kind of ridiculous because obviously the court still has to rule that there is a legitimate lawsuit. They have to rule in favor of the plaintiff. So it's not automatically the police officer receives money from people.
That argument doesn't make sense.
Well, no, qualified immunity makes it harder to sue people. It doesn't mean you can't sue people.
Yeah, you can sue people, but shouldn't certain police officers that actually didn't do anything wrong, the very few that did not,
then
shouldn't
the
they
lawsuits won't be successful because that's how courts
How
work.
will
You have to
lawsuits
have
not be
evidence.
successful? They won't get any form of compensation for it, i.e. the time that they waste in the court system.
So
Anytime
your
money
offense
from
against
that
the
is bad.
counterclaim is just
Okay,
like
that's fine,
officers
that's
have to
fine.
spend a couple minutes
Alright,
in
let's
court.
go
I
to
don't think
case.
that's
Let's go to case. Let's talk about this Fallon evidence. You see that rights trade-offs turns case. Read to me a line from this card that talks about limiting qualified immunity and how that leads to a trade-off.
Yeah, it says that immunity is not a variable among constants, but one variable among others.
That doesn't
in the
indicate
absence
that
of immunity doctrines, courts might prove more hesitant to expand constitutional rights.
If they did not exist at all, that sounds like
It
abolishment,
is
not
literally
about
in the context of
limitation.
qualified immunity. I just read a card that literally
Yeah,
says...
it's in the context of banning qualified immunity. Read to me a line from this card that talks about limiting it.
Some of the case terms might link to the counterclaim. That's why it's conditional. But this is still offense against the plan, which restricts qualified immunity.
It's not
The
specific
evidence
to
says
it's
that
not
the evidence says that the Supreme Court has an ideology of
Okay, that's
equilibrium
fine.
where they
Let's
attempt to
talk about the
counterbalance whenever they
You
make
say that
expansions
liberal
in this
SCOTUS
context.
rulings become crucial, but this argument is just talking about why immigration could have made Republicans uneasy. Why is police brutality uniquely making them
Well, yeah, the second link evidence says that, like, literally more white people think that violence against police is a bigger deal than, like, violence committed by police officers.
Okay.
Proven by the fact that there's, like, the all lives matter shit.
Okay, give me 1 second.
You just said
Oh, now we're getting into cards.
that. Okay.
Do you want me to write out counter terms?
You can do it after.
Okay. The order is going to be the solvency advocate theory, the must specify who pays theory, case counterplan decide. Alright, isn't good? Solvency advocate theory, spec show, case counterplan decide. Everyone good now? Yes. Okay. First on the solvency advocate shell, my evidence literally says that in trying to decide whether a constitutional right is clearly established, courts should first determine whether the official's actions were obviously unconstitutional, i.e. we change the current way that we look at the clearly established clause, and instead of looking at it from the lens of just clearly established, we change it and we decide whether or not it's unconstitutional. It's not a sequencing question, it's a question of the way we look at clearly established, which means I meet the interpretation. The sovereignty advocate does say that we should change the way that we look at qualified immunity, which means it solves all their offense. Also, moving on, just counter-interpretation. The act must be consistent with 3 out of 4 planks of their solvency advocate solves all their offense because it indicates that they could do things like read 3 specific disadvantages to all the other planks, where they could pick out of specific planks. You could also read disadvantages to the one plank that I don't even read, that I don't solve for. Also, you can read disadvantages to the remedy for this should not be drop the debater. It should be that you get your disad grounds, because the only standard of this is predictability, which is key to grounded agitation. The remedy for this is that they should be allowed to read their topical disads and not just have to answer the link back, but they didn't read topical disads, so that's their fault in this specific instance. It's not drop the debater, it's drop the argument. They also say no RBIs. I'm not going to go for RBIs on this because I need this interpretation very clearly, and the counter interpretation solves, and they can read disads to specific planks that I didn't cover. Now let's move on to the spec shell. First, I need the bottom of the Che evidence in part 3 of the solvency says the departments pay money. That's the last line in the card, which indicates that I did specify who pays money in the context of police indemnification, which means no offense on the shell. They also say it's key to things like stable ground and depth. But first, counter-interpretation. The act must specify who pays for the damages if the qualified immunity lawsuit goes through. If asked in cross-examination, solves all their offense because they could just read the disads that they wanted to because they had the disads ready, and then they could just read them based on what I say in cross-examination. It's also solves back for all their stable ground and depth standards because they could go into depth on the topic if they just asked me the question in CS. Also, the remedy should not be the drop the debater because they didn't read this shell's reason to drop the debater. The remedy also, like the other shell, should be that they get their disad ground because the terminal impact coming off of the theory shell is that things like substantive engagement are good, which means the only way to have substantive engagement is if they ask these questions in cross-examination. So it's pretty clear on both shells. I need both interpretation. My solvency advocate says that we should change clearly established and change the way we look at it by reordering it. It's not just saying that we do something else before we look at the clearly established clause. That is not the plan. I also need the second interpretation. The Che evidence says the departments pay for it, which means you can read disads to that. You should read out evidence. Now let's move on to the case. First, on the Fallon argument, this argument is about rights. Turns out it's about a ban on qualified immunity, not limiting on qualified immunity, which means that the disad to the counterclaim is not linked to specific affluent text, which means this argument does not flow for me, it flows to their side. Also, moving on to the Blake's evidence, they say that it doesn't solve police culture. My argument is not that we are obviously going to solve for police culture as a whole, but my argument is that we should probably give victims reparations. Stopping people from being harmed by things like police brutality, stopping them from being shot point blank in the street is probably a good thing, even if we don't solve police culture as a whole. That's the Chen 15 evidence coming off of the one you see in the Carbato evidence, part 1 from the one you see. Also, they say Schwartz evidence that no one will pay. Here you go, you read your funding decide. You could have read this argument. Now I'll answer. My argument is that it's not about whether or not the department ends up paying for it. My argument is that because the department has to keep paying these money for their police officers, they're going to tell the officers to not pay for it, which creates forms of accountability. That's the Che 96 evidence from part 3. Also indicates that things like this isn't offense because things like reparations are uniquely good, regardless of whether or not they pay for it under the lawsuits. We should probably give victims some form of money, or at least give them the chance to try and get their lawsuit tried. Also, they say that people will revolt, but this argument is fundamentally denied. The Jeffries evidence indicates that people would get upset because their lawsuits are going to, and that would lead to the fundamental social change, which means after solvency, I'll say the plan overburdens the federal court, but they've not only linked specific to my impact the counterclaim would overburden federal courts because we only limit it. They're still qualified immunity cases. Now let's move on to the counterplan. First, the counterplan is not competitive. Abolishment and limitation are essentially the same thing. It just adds more restrictions on the qualified community thing, which means perm do both. Also, perm do the often the counterplan. We should probably limit it before we can establish it. It helps us ease it into the system in the first place. There's no net benefit to this, and every single turn they read on case links harder into this, and also elections link much harder into this because it means that it would be complete ban. Also, there's a disadvantage to this counterplan. It would be that officers that actually deserve qualified immunity, the fee percentage would not be afforded these protections, which means their constitutional rights would be violated. Now let's go on to the disad. They concede that normal means that we implement things through the Supreme Court, and their next hearing is on November 28th. That means that they cannot have a meeting on whether or not they want to pass the plan until the 28th, which is after the election, which means no link to the disad. You should have clarified about what normal means. They literally read Supreme Court specific evidence, which means no link to this argument. Also, the case outweighs on a probability because it means stopping things like police brutality is probably a much higher probability than stopping Trump from coming in power because either A, he'll come in power and status quo in this impact is inevitable, or B, clearly Christian will win the electoral college.
240. where is the part that says normal means is SCOTUS?
That would be the arguments in your dissent. That would also probably be the solvency advocate for the plan text because it's literally talking about courts. Like the internal link evidence in your dissent is about the Supreme Court. They're the only ones who rule on qualified immunity.
So the internal link evidence in the dissent determines qualified, or determines normal means of
No, it's not just that. It's also just the basic fact that the courts are the only people who've ruled on qualified immunity in the past, which means they would be the only people that have the authority to either A, reverse their decision, or B, change the doctrine. Also, my evidence is about the courts. Catlett is talking about what courts should do.
Alright. The order is the shells in order, and then
Wait, what's the order?
right, solvency advocate, and then funding, and then the counterplan, the dissad, the case. Is everyone good?
You probably should have made one sketchy reinstantiation of the plain text in the one area as your only answer to dissent when there's reason why the dissent outweighs and mishandle a lot of the case here. But start on theory. Start on theory. You may think there's a ridiculous argument that there's an easy auto-negate because you have no offensive fairness, which means that I only have to win that you violate the text of the interp. You say that you beat because you changed the current ways that it's interpreted. But you should call for the plain text. The plain says that we should change that we should get rid of the clearly established standard and replace it with clearly unconstitutional. The solvency evidence says that we should keep the clearly established standard, but instead use constitutionality to determine that, which is textually different. Text of the interp comes first because otherwise they, or because the text of the interp comes first because it's the only stable basis for any alternative justifies infinite abuse and unpredictability. It also means that we can't set norm because we don't know what the actual norm is specifically. What the actual norm is specifically. Also, no due to your arguments on this question because they didn't justify spirit of the interp first and didn't have any reason why they meet the text of the interp. Now, summation of the theory shell is easy. You just have a defensive argument. You say your counter interp is 3 out of 4 planks. You say that it solves the offensive. All of my offenses, specific to the fourth plank, which is about getting rid of the standard altogether. You consider that no author actually says this, which means that there's no gray ground. All I need to win is that there is a risk of fairness offense because you consider competing interests, which means that you automatically have to vote on the shell. Now you say that the remedy should be that you get your dissaz, but I didn't. I had no idea whether that you would say this in 1 AR. So obviously I could. So I shouldn't. It's unstrategic for me to just read the dissaz in 1 AC and then just bank on you being able, bank on you making this argument in the 1 AR. B point. You can see all the reasons to drop the debate. You can see that substance is permanently skewed, which means that we can't go back to it. We can't go back to it. Also, it's key to deter it, and also this means that if I get dissad links, you are suffering out of the 1 AC, which justifies skewing my strat. Now, not going for the second shot, not counterplan, not going for conceded from justice test of competition was conditional. Big problem because all of your arguments on case are just like this links to the counterplan too, but also links to the app. Now the dissad, you only make one argument, which is that the Supreme Court's normal leads to the plan. 3 arguments. First is that result implies immediacy, which means that the plan has to happen now, so you can speed up the debate in the Supreme Court meeting. Second, much more intuitive argument. The plan text literally says United States federal government. You say you say 2 things during flex prep, which doesn't matter anyway. But you say that first during flex prep, you say that the dissad internally talks about the Supreme Court. That doesn't matter at all. Obviously, it doesn't clarify the normal needs of the plan. The other thing you say is that the solvency advocate talks about SCOTUS rulings. But that doesn't matter because you defend the text of the plan text, not exactly what the solvency advocate says, which means that obviously it doesn't clarify what you actually defend. Also, empirically proved by the fact that you changed your plan text from the Supreme Court of the United States to the United States federal government should, which means that obviously there's some distinction. Also, you say that it's impossible for the Congress to do this, but that's not true. The Congress can amend the law that they already made that gives the law that they already made that protects police officers, which means that your argument is literally just false. Now, you only make one argument, which is that the probability because police violence is happening on the status quo. You consider the terms case argument that Trump obviously exacerbates this. He says that there is literally no problem with over-policing the status quo, which means that he would roll back the app that is conceded, which means that you get 0 risk of offense. You've also conceded multiple external impacts, which is the tiebreaker question. Ask yourself how a Trump presidency could not possibly outweigh the only app impact sufficiently extended in the 1 year, which is that people get material redress for all of their harms obviously does not outweigh Trump literally massively increasing anti-black violence in the streets. Now, you've considered the diss app proper, the Hillary will in this quote, but it's close, and the final disruption would flip the race, but empirically proven in the context of Comey, where final distraction distracts people from Trump's record, which means that they will switch their votes. You have conceded both of the link arguments. The first is that it leads people to rally against the liberal Supreme Court movements, empirically proven by affirms, etc. And you've also conceded that independently white racist people will backlash against this because they think that violence against the police is a bigger problem. You've also considered the impact card, which is proven 821, indicates that Trump literally does not think racism is a problem and will cause multiple scenarios for conflict and all sorts of violence and Islamophobia all around the world in the case. Stenfeld in 11, there's a rights trade-off. Your only argument is that it links to the counterplan and more because the counterplan is banned. The evidence says that when we restrict immunity, then subsequently the course endorses their doctrine of equilibrium, which means that they would subsequently reduce the likelihood of constitutional of granting other forms of constitutional rights. Also takes out the internally to your impact because it means that even if you clarify the Constitution, the Supreme Court will actually grant those rights because they want to establish an equilibrium. This turns the case because any reason why the act is not able to solve is the reason why the subsequent rights violations that the Supreme Court would endorse are probably outweigh and are comparatively worse. Now, the blanks 15 evidence, you say the blanks 15 evidence still provides as a significant mitigation. You literally conceded that police culture will not change and that people will not reduce the amount of brutality, which also takes out the internal, which means that the only external impact you have is the funny argument. That takes your argument that people will get upset and revolt against it, or that people revolt against it, because, or that the departments would tell officers to do things because you conceded that the culture is intractable. Police officers cover for each other, and there is just a conception of the right way things are done, which is not likely to change in the status quo. Now, extend Schwartz 16. Extend Schwartz 16 payment will have no effect. You've considered that even if the police departments are the ones that are actually paying the money, it doesn't matter because you've considered there's no financial burden because the money that they are used to pay for these lawsuits is given to them during the budgeting process, so it doesn't deprive them of any money that they wouldn't have otherwise had. Takes out your response, which is that they would still tell officers things. No, they have absolutely no incentive to do that. Now, last, the Putnam 92 evidence indicates that courts would be clogged and there would be no room for lawsuits because literally the judiciary would collapse. That is pretty damning because it means that the only internal link that you actually go for in the 1 ER, which is that people get redress for people get redress and get money from damages, means that it can never happen because lawsuits wouldn't happen in the first place. Your only argument is that the counterplan links fine. The counterplan links, but the app links too. This is also offensive for me because it means that at least in the sense where there are a couple successful lawsuits on the basis of the Fourth Amendment or excessive force, etc., but that could literally not happen in the world of the plan. Even if you think it's hyperbolic, you have considered the claim that it would collapse the federal judiciary, which means that there are no lawsuits, which takes out any remnant of any kind of internal link that the app could have to solvency. So vote nay. It's a pretty easy technical theory ballot, and you've also really mishandled the turns on case. I don't need to win that you link to elections because you've just not explained that the app's a good idea.
Going to be theory, case, and then dissent. Okay, is everyone good? Okay. First on theory, the only answers that I need are that I don't textually meet the interpretation, but my argument is that Kaplan is a solvency advocate for the plan. Literally, the line from the card says, instead of determining clearly established, courts should first determine whether the official's actions were obviously unconstitutional. It's not a sequencing argument here. It's in place of clearly established laws. We modify it and we add in the side constraint of whether or not they should determine whether or not the thing was clearly unconstitutional, which means we modify it and we change and get rid of the clearly established laws, which means I meet the interpretation. Their argument is that I need to have a solvency advocate, but yes, we change my plan says that we should change the clearly established, right? by getting rid of it, i.e. modifying it and adding in something else that is different, changing it and getting rid of it. Which means I make the interpretation. But even if you don't buy that, I'm winning the counter-interpretation. The only arguments are that it's not specific to the fourth plank and that the fourth plank is key. They have not contextualized this in the context of the voters of the round. I made 2 arguments here with the counter-interpretation. I can just mean 3 out of 4 planks because you can either A, read this as a solving example to the one you see, there's reason that's why I don't solve for everything that I advocate for, or B, you can also just pick out of the fourth plank or pick out of specific planks in the one I see and you distance to the other planks, which means this fundamentally explodes predictability and also explodes ground, which means I control the internal to all of your fairness. In fact, also, they concede the remedy should be viewed that you should read your dissent ground. The only answer is that there was a permanent skew, but my argument is that you should be responsible for these dissents. If you want to substance engage and have education, then you should read these dissents. But now let's move on to case. First, on case, the arguments don't make sense. They extend Fallon and say that this is a rights trade-off because of limiting qualified immunity. Their card literally says absence of qualified immunity, which means a ban on qualified immunity. There's still qualified immunity cases in the world of what I see, which means that there is no rights trade-off. And obviously giving people things like reparations outweighs as per the Che evidence. They also say the change won't happen, but my argument is that things like reparations and stopping death is what causes the change. Even if police culture is still bad, we should probably give people money to allow them to live with these issues that have been caused by the system. Also, their arguments on the Schwartz evidence is that there will not be any form of incentivization, but the Che evidence is pretty clear. The department will pay the funds, and they don't want to keep paying funds, which means that they're going to deter the officers from doing these bad actions in the first place, which means that either A, I win accountability, or B, I win that things like reparations are a good idea, which means you can vote on that. Also, their last argument is just that the plan would overburden the federal court, but no, they've conceded the argument that there's still qualified immunity in the world of what I see. They've also conceded that things like deterrence from the solvency that I'm generating from the Che evidence means that we would fundamentally solve because there would be less cases because officers would be de-incentivized from doing these negative actions that would result in them being sued in the first place. Now on the decide. First, there are only arguments that I don't prove that, like, I specified the USFG. The USFG is made of Obama, Congress, and the Supreme Court. The only person who has the authority to make any sort of claim about qualified immunity is the Supreme Court, because they are the ones who expanded the doctrine in the first place, which means normal means is the Supreme Court. They're the only one who ruled on qualified immunity and created the doctrine in the first place, which means the only time that the hearing happens is on the 28th, which is after the election, which means no link to the impact, and the impact coming off the case is much higher. They say that there's a risk of a Trump win, but no, they can see the argument that either A, Trump was inevitable, or Hillary will win the Electoral College. Their polls don't take into account for that argument. So the argument here is very clear. The only person who has the authority in the government to do things like this is the Supreme Court. All of my evidence catlet is about the courts, which means they are the ones taking the action, which means no link to the elections is that and no impact. You can vote on giving reparations to people, gives them intrinsic human dignity, and also solves the forms of violence they face in the status quo, always on probability, because that is the most material thing we can do. Since they see right here.
but I think that might have been causing problems. When I said flow.
Ali.
Yeah.
What?
It's not.
Yeah, okay, yeah. Can you have it exactly?
Yeah, I can write it down.
Okay.
And you have the card in the.
Yeah.
Okay. Can I message that to you?
Yeah. We could also just like
Oh.
I mean, I actually put time here.
It was just the AF must read a solvency advocate that explicitly advocates for everything.
Is that nothing real?
Okay.
No, I was writing comments.
Hey, get back in.
I'm fourth. It's a psychological thing.
I'll take one at a time.
Thank you. All right, everybody. In what I'm sure was a fantastic debate, the winner on a 3-0 is the negative Cambridge.
Okay, I'll start. So I thought the round was really close, or it could have been really close. Or I think it came down to there were I'll clarify what I said. There were a lot of things going on in the round, and I think the app is winning a lot of arguments, but they are. I think the app is mishandling Fallon, which is where I ultimately negate. I think the election DA clearly has no link. Does resolve mean immediate? I don't know. The plan text doesn't include the word resolve. Maybe the plan's on top of them, but whatever. No link. The T, I guess I don't have a strong opinion on winning theory. I think that it is the text of the card is this over. It's the question of whether the like in trying to determine whether the right is clearly established, like what portion of the paragraph that clause modifies. I think both of you are like I think both of your explanations of what the card says are wrong, but I don't know who's like objectively right, so I don't really know what to do. I think I can negate on the case turn, so I don't have to deal with all that. The response to Fallon is that not banning QI or not abolishing QI doesn't link. But Fallon says appeals to like the warrant in Fallon is that there is an equilibrium thesis, which is that like courts will when if they give a right, they'll take away another right. The like scope of the rights transfer, I don't see how that's relevant. So I think that the like warrant in the card applies just as well to like a limitation of QI as opposed to a elimination of QI, because in both cases like courts counterbalance shifts in amounts of rights. So and then there's like the weighing analysis that Tuan does, like that like if there are solvency indices to the rights that the app establishes, that means that the other generic rights are better. Like you should be like pressing harder on like what are these rights violations. It's like pretty vague what they are. I don't know what they are, and like probably a lot of the defense he reads on case probably applies to other generic rights violations, because if courts extend one right, take away another right from like people who are victims of police brutality, but like those rights probably don't matter if the solvency index probably covers other rights anyway. But given that weighing analysis, I think that the neg is winning a lot of the app has a risk of offense, but like the neg is winning a lot of solvency index. The Schwartz evidence seems a lot more specific compared to the Shea card. The Shea card is like not really empirical. It seems to be more like a logical argument for what would happen. Schwartz is pretty specific that police departments have a preset allocated budget dedicated to lawsuits. So like they're at the margin, there's like no reason the police department would care. This isn't like you should say that like in the long run, there's like probably a political incentive to reduce the cost, even if in a given year the police department has no incentive to change its practice. And like I think there's probably empirical evidence that says that. But these defensive arguments are like not just winning to some defense, which given the weighing valid means that I think that like whatever mystery rights the app trades off with are more important. So
I think that, I guess me being more frivolous of the three of us, I kind of look at this Solvency Advocate show, and the reason why is because I read the show a lot. Well, like I made my way into it now. And I think that it's kind of true insofar as like the text of the enter, right, is very like, it doesn't say what he's saying to say. I think that your enter, even if that's the case, I still don't think that it necessarily, I don't know how to explain it, but like I feel like the counter enter on it, right, it's like I have to meet 3/4 of the plane. I think even if that's true, I still don't understand why exactly, like the author just does not necessarily say it in that way that the plain text structures it, and I think that is problematic necessarily, right, and that there are two different parts of the, like if they're in the same sentence and he was just like being super technical, like it has to go this way, that would be completely different. But I think that like insofar as they're like completely separated by like several other lines in the card, which is what like feeds the enter, I think I'm buying that enter. I also buy the argument that like that like it's already been skewed, you didn't justify the spirit of the enter, things of the nature I think is probably problematic for the 2A. Or for the 1A that ends up being 2AR necessarily. I can also go on the case way with Josh, but like I guess like I don't necessarily need to go that far insofar as I'm buying this theory show half-assedly, I guess you would say. So yeah.
I feel like I could just like complete the trifecta and say I voted in elections DA just to 3 different RFDs. But no, there's just like non-elections DA that link is just link is silly. Like I mean maybe if you made some like theoretical arguments like the plan must pass immediately, anything else is unmeaningful, et cetera. But there's no definition of result that's supported by card, and the plan does not say result. Theory potentially would come out on the side of the negative. I do think that the plank of change in the plan text is not necessarily warranted by your author. I was slightly more convinced by the next reading that's just like, in trying to decide whether constitutional right is clearly established, we change the test for it, but we don't replace the clause clearly established right with, or we don't replace the clause clearly established right to clearly unconstitutional. But, it's a bit muddled, so I'm more in line with Josh's reasoning of voting on the case turns page. So I think, the Fallon card is a little bit better than you give it credit for in the 2AR. I think Josh's explanation of like why it is offense is pretty good. Like the equilibrium stuff. If you limit qualified immunity to trade off rights in other areas, because it's part of the package. I think that the Schwartz evidence means that it doesn't deter cops. I think it's empirical. I think your Che evidence is sort of answered pretty well by the Schwartz card. It seems like the only offense to this point is reparations of money good. So one of the other things I'm a bit confused about is it seems like the more you try to no-link from the case turns, the less solvency you would get, because you're like, there's less qualified immunity, but it also seems to undercut how much, you would pay other people, or how much you would deter the cops and whatnot. So it seems like the more you're like, no-link, there's still a lot of qualified immunity, so don't link these court stuff. It seems to undercut the solvency for the act. So that's one other thing. The lawsuit stuff, you probably don't collapse the entire judiciary, but I still think that there's a pretty clear implication in the 2NR, which is like, you would still overburden it enough that it would make the lawsuits that you pass pretty unlikely. I think that's offense if you make it slightly worse than the status quo. That plus a lot of mitigation on the app, like police culture intractable. They're going to still do whatever they want, apparently. It means that I can vote on both the Fallon and the court club turn combined.
Thank you.
Questions?
Thank you. Better answers to theory in the case page than the one Eric had made.
That would require me to think, and it is 10:30.
I think very easily, I think one you should probably, I can speak for the theory part, I think, is that you need to say, like, I think your counter-interp should be along the lines of spirituality of the interpretation, especially because in the one is he doesn't go for textuality necessarily. Like, he doesn't, like, you need to hold her to, like, the text of the argument, right? He's like, you don't go for spirituality, which means you should go for textuality, right? I think that you need to just find the spirit of the interp coming out of 1AR immediately. I also think that you need to be putting some type of RBI on this argument, especially if you can easily meet it. I feel like, just like, why not, right? Like, I feel like going for an RBI in this instance is like a zero risk issue for you necessarily, right? Because, like, if he beats it back, great. That just means that he spends more time on it for no reason. If he doesn't, then you kind of win an RBI and you have an offense, and then you get what I'm saying, because that makes it 2AR a little bit easier and it keeps your options open. I feel like that's like probably the most, like the best two-point combo I think you need to do on this theory show.
Okay, that makes sense.
The case page arguments, it seems like the culture argument and the payment has no effect would just be like, do you have a card that empirically indicates the other direction? The court clock stuff, you could just answer that like a DA. This Fallon stuff, I do think you're correct that like this card is about getting rid of qualified immunity, though I just don't think that's enough to take out the entirety of the turn. So I think that mitigates it a lot anyways in the face of this turn. But I also, when I read this argument, like I don't really understand 100% the reason for why immunity necessarily entails a trade-off in other places. Like the card seems very speculative. It's just like maybe it's part of some package that if we reduce in one area, we trade off with others. And if you just like read a card or extend a card from the app, it's like nah, there's actually not a trade-off. Like it empirically works and deters like people. And there's definitely not an explanation in the 2NR of like which particular rights get traded off as a result of the app. Like it seemed very vague. Like I don't understand like what right they could possibly remove. That would be so bad. Whatever. Those are just my initial thoughts, though.
Okay.
I think the AC needs like more specific solvency evidence. I think that like these case responses are pretty common, and like you should be extending evidence on the AC to take it out. Like starting that debate into 1AR like puts you behind if there are like other offs like theory, which is what happened in this run.
Okay.
I will say I was very impressed that you answered the elections DA in like 10 seconds without a card. And without
Very
I was like, yes.
You only deserve 10 seconds.
Yeah.